I'll now use this opportunity to welcome everyone, especially our council members. We recognize quite a number of our council members on this call this afternoon. We also want to welcome our very special guests, the VIPs amongst us, and of course, all of you distinguished ladies and gentlemen. We would like to also recognize our host, the president and the chairman of council, Mr. Bode Ayeku, as well as our chief, the speaker, the distinguished guest that we will be having this conversation with this afternoon. I'm talking about none other than Alhaji Garba Abubakar, the Registrar-General of the Corporate Affairs Commission. Really glad to have you here, sir. I would like to hand over to the president at this juncture for the opening remarks. But before I invite the president, may I please remind us about a couple of ground rules? Please drop your questions, your comments in the chat box, and we'll pick it up from there. It's an interactive session, so we expect that we'll see a lot of questions, a lot of comments. So please make use of all of these tools as we go right into the conversation this afternoon. So I'd like to hand over to my president, Mr. Bode Ayeku, FCI, the president and chairman of the Governing Council of the Institute of Chartered Secretaries and Administrators of Nigeria. Mr. President, over to you, sir.
Okay, good afternoon, ladies and gentlemen. And if it is not too late, let me also say compliments of the season. It is our pleasure to host you this afternoon. This happens to be our first program this year, and it is to discuss this important topic. In view of the fact that I am aware that some of us are not only chartered secretaries and lawyers, we have a chairman of our board of directors with us, some directors, and also some notable people who are joining us today. It will be necessary for me just to give you a brief introduction into the Institute. The Institute of Chartered Secretaries and Administrators of Nigeria is an offshoot of the international body, that is the Institute of Chartered Secretaries and Administrators in the United Kingdom, which was founded in 1891 and got its royal charter in 1902. The Institute in Nigeria started informally in 1944, when some Nigerians who studied abroad, who became chartered secretaries and administrators, came back to Nigeria and decided to form an association of chartered secretaries. However, officially, this institute elected its first president in 1966, and thereafter, we got a charter in Nigeria in 1991, as a professional body recognized by Act of Parliament and as the only professional body recognized to conduct examination leading to the qualification of chartered secretaries and administrators of Nigeria. We've been around for this period of time, and we've been contributing our quota to the development of the country. And for your information, we've been having very good relationship with the Corporate Affairs Commission over the years. And it may interest you to note that the first Registrar-General of the Corporate Affairs Commission happens to be a charter secretary. And he was our past president of this particular institute in person of Chief Chris Atoki. So we've been having relationship with the Corporate Affairs Commission over the years. And this particular one is an ongoing relationship. You recall that last year, we also had a webinar and with the CSC participating actively, and we were able to address a major issue of interest to all stakeholders. And it's in furtherance of that, and in view of the fact that the Corporate Affairs Commission is a body established by law to serve Nigerians and Nigerian businesses. Whenever there are issues of interest, we are always happy to discuss with the Corporate Affairs Commission. And it is gladdening to note that the wonderful engagement that the Corporate Affairs Commission has been having with stakeholders in the last few years, particularly last year, has been so commendable. You recall that when COVID came last year, there was concern as to whether and how AGM should be held. And the CAC also collaborated with relevant stakeholders and came up with regulations that have been assisting companies to hold their AGMs. And if you also note the series of engagements after the signing into law of the Cama bill last year, thereafter the upgrade of the portal of the CAC, it shows that it's a commission that is always willing, ready to listen and also adjust to developments. And the good thing, which is of interest to us as an institute, that we're also happy that CAC has never maintained a rigid position. Whenever they listen to very sound arguments as to why some principles or policies should be changed, they've been doing that over time. And it is as a result of that also that we are confident that the theme of this particular webinar will be in a position to resolve the interpretation of this particular area, and we will be in a position to arrive at a workable solution that will be in the interest of the country. As professionals, we are trained to listen to others and also for others to listen to us so that we can jointly agree on what is best and also what is good and in the best interest of the country and business. And we are sure that we will have this engagement today and we will be in a position to discuss this particular issue. Just for your information, this particular theme I came about because for the first time, the chairman of a board of directors actually called me to draw my attention to this particular provision and ask for my advice. The chairman of the board actually called to inquire if that was true, that the company secretary of that company advised him that they should issue all their issue shares before 30th of June, failing which there will be a penalty. And the company secretary actually forwarded to the chairman a memo and also attached the regulation. So it's as a result of that that the chairman of that board actually called to find out what could be the rationale behind it. And thereafter, this has been a very hot topic in most of the professional platforms that I belong. And that is why we just need to look at this topic and then look at all the various dimensions to it so that we can take a decision. And just to clarify, this particular thing is in respect of existing companies that have more than the prescribed minimum issue share capital. You know, the prescribed minimum issue share capital is defined in section 27.2 of the Companies and Allied Matters Act 2020. For private companies, not less than 100,000. For public company, 2 million naira. So if a company has more than the prescribed a minimum issue share capital, and for those in special sectors like the banking insurance, they have their own prescribed. So that will be the minimum for this purpose. So this topic is not in respect of those companies that are having less than the prescribed minimum issue share capital. It's in respect of companies, existing companies that have more than the prescribed share capital but still have unissued shares. And if you look at the provisions of section 124 of Cama, it covers both new companies to be incorporated and existing companies. And the provision of section 124 is to defer that any existing company or any new company to be incorporated must not have less than the prescribed minimum issue share capital. However, if you look at section 13 of the company's regulation that was recently released, the section, although is referring to existing company, that section talks about unissued shares, whereas section 124 of Cama talks about minimum issue shares. The company's regulation gives maybe a different definition in terms of narration of what is required. For the company's regulation, it is stated that any company or all existing companies having unissued shares must fully issue the shares by 30th of June. So the purpose of this particular discussion is to find out, are existing companies prohibited from having unissued shares even if they have more than the minimum issued share capital after 30th of June 2021? And we will be in a position, at least with our guests today, to get an understanding of that particular one. And the point that should be noted is that there are various reasons why companies have unissued shares. Unissued shares for corporate bodies is like savings to individuals. You save not because you have idle cash, but you save because you will need them to fulfill some obligations. The same thing applies to companies. They have unissued shares to meet their pending or planned obligations to relevant stakeholders. And these particular obligations, for example, what one of the discussions I had with a key stakeholder was that they have this obligation with a key stakeholder that is not yet due. And if they are now being forced to issue the unissued shares before the due date, so what will be the implication on the business? So we'll be looking at this particular dimension today, and we are pleased to have with us the Registrar-General of the Corporate Affairs Commission. He is currently attending a meeting of PEBEC, Presidential Enabling Business Environment Council. We hope he will join us shortly. However, in the interim, we have his representatives who are with us, the Director, Mr. Midia, and also Mr. Director Registry, and also Mr. Tolulope Shonaike of the Corporate Affairs Commission. And they will do justice to that at the appropriate time. So I now hand over to the moderator to read the profile of the REG.
Mr. President, thank you so much for the opening remarks and laying a solid foundation for the conversation this afternoon. We're really glad to have that few comments from you, putting everything in perspective. Alhaji Garba Abubakar hails from Bauchi State. He was born on the 7th of October, 1966. He attended the prestigious Hamadu Bello University, Zaria, and was called to bar in 1989. He joined the Corporate Affairs Commission in April 2004 as Principal Manager Compliance, and he rose through the ranks to become a director in January 2016. He was Special Advisor to Bello Mahmoud, the then Registrar-General of CAC, between August 2010 to October 2017. Prior to joining the CAC, Alhaji A.G. Abubakar worked with the Nigerian Social Insurance Trust Fund, formerly called the National Provident Fund, as compliance officer between 1991 to 1993. He also worked at Nikon Insurance between June 1995 to December 1997. He's a member, Governing Council, Nigerian Bar Association Section on Business Law, March 2017 till date. He's also a member, Interagency Committee Against Money Laundering and Terrorist Financing, 2007 till date. CAC focal on open government partnership, amongst others. Alhaji Garba is also a member in-house committee on the review of the Companies and Island Matters Act, Cama. Ladies and gentlemen, we're pleased to have the Registrar-General, ably represented by the senior executives of the CAC. Mr. Tolulope Shonaike is with us this afternoon. We're yet to identify Mr. Justin Mudia, but Mr. Tolulope Shonaike, you may please unmute your mic as you have the floor now, sir. It's good to have you back. Okay. Over to you, sir.
Okay, sorry for the interruption. Like I was saying, the RG has to go for a PEBEC meeting with the Vice President. I've been instructed to represent him, and it's my pleasure to be here. I have read the concept note that informed the webinar. We have looked at the particular section that is in contention, that is section 124. We have also looked at regulation 13, which has raised
again. Let me try to say something quickly about what informed the development of regulation 13, which has raised concern across board. When we look at section 124 of Cama, it clearly provides for existing companies whose share capital is below the prescribed minimum of 100,000 for private companies and 2 million for public companies. It requires those companies to raise their capital to the prescribed minimum issued capital and then file notice with the commission. Now, when you look at section 868 of the Cama, the definition of share capital of a company clearly states that is the issued share capital of the company. So what it means is that going forward, there will be no room for nominal share capital of a company. So that was what informed the development of regulation 13, which was to provide an avenue for companies who have met the prescribed minimum share capital requirement to now move from nominal share capital to issued share capital. And the commission has tried to encourage practitioners to do that. That's why it prescribed a period of 6-month transition for those types of company to actually issue the share capital and file the notice with the commission. And it not only provide that, it also try to encourage those type of companies to do so. That's why if you look at it, it says that within the 6 months is free of charge. So it's only after the 6-month period that you will now be penalized for not doing so within the prescribed period of time. So when you look at it technically, there is actually no conflict between regulation 13 and section 124, because section 124 deals with companies whose minimum authorized share capital is not up to the prescribed minimum, while regulation 13 deals with companies who have met the prescribed minimum share capital but still have outstanding nominal share capital that have not been issued. The commission recognizes that for public companies, for instance, they may require more time to comply with that regulation, but for private companies, it is a thing that they can do within a short period of time. So the commission has taken note of the representation from Julius Berger in particular, who have pleaded that, other people that have pleaded that they should be given time to comply with those regulations. So let me stop here with this brief remark so that if there are questions and answers that will come up as a result of the discussion, we will be willing to answer them. Thank you very much.
Oh, thank you, Mr. Josie Nidia, for the introduction you have given. We thank you also for representing the Registrar-General. And just to inform the participants, the Registrar-General also just reverted that as soon as he is done, he will join because he's also eager to contribute to this discourse. As you rightly said, sir, the reason why there are concerns is because we have the provisions of Cama that is section 124, that deals with both new companies and existing companies. And section 124 provides that if any company has below the minimum issue share capital, that company must comply within a period of 6 months. However, the regulation 13 that you refer to of the company's regulation actually deals with not issue share capital, but it deals with unissued shares. And the real concern of stakeholders is that in Cama, stakeholders are yet to see any provision in Cama saying that a company cannot have unissued shares. I think that is where we will appreciate your maybe additional information. Maybe if you can draw the attention of stakeholders to the provision.
Okay. Can I respond to that?
Yes, sir.
What we said initially is that when you look at section 868 of Cama, it defines the share capital of a company to mean issued share capital. What that means is that any form of capital is not permitted. So that was the reason why Regulation 13 was crafted to allow existing companies that have made the threshold to transform or to move from their current position of which have 3 layers of capital, that is nominal, issued, and paid. Because the spirit of the act is that we should have only 2 layers of fees issued and paid up. So that have not been issued to move from those positions to a level of 2-tier capital, which is the spirit of Cama. I don't know whether you understand our submission.
I got your information. Just for you to confirm, I think I heard you refer to section 868 of Cama as defining issue share capital. Is that correct, please?
As defining share capital for companies.
Yes. I just want to read that section 868 so that we can be on the same page. We have 2 definitions there. The first definition is issued generally, and is defined to mean in relation to a prospectus issued to persons who are not existing members or debenture holders of the company. And then we have another definition, issued share capital, which is defined
No, that is not the one. If you look at, there is one that has to do with share capital. If you look at share capital, look at that definition very well.
Okay, I'm there now.
Okay, read it.
Share capital means the issued share capital of a company at any given time.
Very good. Did it mention any nominal capital?
No, there is no definition of nominal there.
So the spirit is that when this act comes into effect, companies would be uniformly required to have issued share capital. And that is the reason the Commission actually brought in Regulation 13, so that companies that have nominal capital that have not been issued could move from that position to companies that have issued share capital. So I don't know how something that was conceived to help companies tidy up their position could now generate unnecessary controversy.
Let me just respond to that. The reference to controversy basically is. Can I respond to that, please?
Sorry, sir, Mr. President, the RG is here.
The RG is
Okay.
Mr. President.
Good afternoon.
Mr. President, good evening, good afternoon. My apologies.
It's accepted,
I had
sir.
to be at the Federal meeting.
You are welcome. You are welcome.
Thank you. I believe my colleague has addressed some of the issues.
I think you can also start so that all the participants can listen to you live.
No, the position is the same. You see, we all knew Tony that led to the passage of this law. And even after the assent, we all recognized some of the gaps. The law is not perfect. Some of the provisions are not consistent with some other sections of the law. So what we try to do is to try to address some of these challenges through regulations, pending when an amendment will be made to the law. My understanding is the debate has been whether on what constitutes issued share capital, and whether from the provisions of the law as well as the regulations, whether companies can still leave some of their capital unissued. I think the use of the terminology issued has said it all, despite whatever gaps you may have in the law. If the intention of this law was to retain the authorized share capital, then you don't have to change it to use the terminology issued. And it will also be ridiculous to canvass the position that by issued, it means the minimum issued share capital prescribed, which is 2 million for public company and 500,000 for private company. Because take for example a company that has 1 billion share capital. So the import of some of this interpretation is that a company with 1 billion is only obliged to issue 2 million out of that 1 billion. That position is very retrogressive and it's not even consistent with what we had before. So we've been part of this process, and we agree because the law had gone through a lot of processes before it was eventually passed. Some of the provisions had actually been modified, sometimes without recourse to the original people that did the first draft. But our position is, as an agency responsible for implementing this law, we have to do what we believe will give the true intent and purpose of these provisions. So we are constraining issued share capital to mean that everything that the company has as its capital must be issued at the point of registration. We are not narrowing it to the prescribed minimum issued share capital of 2 million or 500,000, irrespective of public or private companies, as the case may be.
Okay, can I respond?
Yes, go ahead.
Okay, first and foremost, let me also appreciate the comment you have just made, which has been consistent with your policy and the way you interact with stakeholders over time. You acknowledge the fact that there are gaps in the law, and that is good, and that means that it is work in progress. And whenever there are gaps in law, as much as possible with the stakeholders, we jointly work together to find a way to close those gaps. We also know that there are the agitation.
Hello? You take that?
Hello, can you hear me?
I couldn't hear you. Yes.
Okay, let me start again. Hello, can you hear me now?
Mr. President.
Yes, can you hear me now?
Can you take that? Can you take that again, please?
Okay, I will.
Can you take that again?
Yes, I will take it again. I said I must also appreciate the point you have made that there are gaps in this law, and it is consistent with your approach in engaging with stakeholders over time. that you also be bold enough to say if there are gaps, and then there is the need to find solutions to those gaps. And as I said, since the release of Cama, there has been concerns raised and gaps identified, which stakeholders are also working together to find a way in form of an amendment to the Act. I understand what you are trying to say, that because there are gaps, we should be looking at the spirit of the law. But the good thing about this engagement is that the CAC has several stakeholders, and they also need to listen to the stakeholders so that when we are trying to close these gaps, we can look at all the issues together. I listened to the point you have raised in respect of the issue share capital.
No, but sorry, Mr. President, that's clear, Mr. President, but I think we also need to advance our minds to some other provisions of this law, like Section 868, on what a share capital means, and other provisions generally. So let's not just limit it to 124, because by narrowing it to 124, sometimes we cheek, we pick what suits us because of the directive that most companies have to issue the remaining unissued shares within 6 months. So that is what has led to this debate. And so we should look at all the provisions. You know, a lot of other provisions had raised similar debate. A lot of issues had been raised with other provisions, not necessarily this one. And what we try to do, as I have mentioned, is from the regulations, we try to clarify. We know the regulation cannot supplant the law, but it can bring clarity in the way the law is applied. So what we have done in the regulation is not actually to supplant any provision of the law or introduce anything that is inconsistent with the law. So, but to give full meaning to the provisions of the law. So I believe stakeholders, Icsan is a key stakeholder. The new law has even made you a member of the board, so we'll soon come to you on that. I believe, as we have said, this is an issue that all stakeholders should come together and agree on the way forward. The provision on issued share capital is not peculiar to us. Some of the provisions of the new Cama were borrowed from other jurisdictions. So many jurisdictions have dispensed with the issue of authorized. In fact, in some jurisdictions, you don't even register share capital. But in Nigeria, if you do that and leave that to the company, that would be a behavior of confusion. So it was agreed, the consensus was that our journey should be gradual. We shouldn't come with things that are too radical that may end up distorting the whole concept of company law and practice. But for most companies that have authorized share capital, some of them have had this authorized for an inordinate number of years. And these shares are just warehoused. They are not issued. There is no idea inside for the issuing them. So why must you have authorized? It's even a saving for some of these companies because you don't have to pay stamp duty. You don't have to pay registration on capital you don't really require. And you are at liberty at any time to increase your share capital whenever the need arises. So our position is, we don't think this should even be a matter for debate. This shouldn't be a matter for debate. As we have said, this law is not perfect. And it's the same thing with every human endeavor. No human endeavor is perfect. But maybe we could have gotten it better than what we have if some of the interventions and some of the things that took place as a prelude to the passage of the bill had followed maybe all the due. Because if you remember, this started with the 8th Assembly. Even after the 8th Assembly had done it, it had to be represented to the 9th Assembly as an exec bill. So a lot of things happen in between. You wouldn't know at what point. And at the point of getting this law passed by the 9th Assembly, everybody was concerned about getting the law in place. So nobody wanted to initiate anything that will further delay the process, because one critical issue that will have even led us to actually delay the process was the issue of electronic meters for public companies. As urgent and important as that issue was, we had to put it aside just to get the incentive. Because if we had introduced any change on that area, that would have delayed the process by another 6 months to 1 year. So these are some of the issues, and my appeal to all stakeholders is, let's move on, and there are matters that will come up later by way of amendment. For us as the implementing agency, we're also looking at the whole gamut of the law to identify the gaps, and we won't do it alone. We'll involve all stakeholders, similar to the approach that was adopted in the passage of this bill. We'll adopt the same approach, as well as our relations, because even the relation was exposed to all stakeholders. I'm so pleased. This area didn't elicit comments at point, because the position of the regulation on issued share capital was very clear. But we didn't receive any adverse comment on that area up till now. So up to the time the regulation was actually approved by the Honorable Minister. So our appeal to all stakeholders is, let's move on. As I've said, no human endeavor is perfect. As time goes by, then we'll begin to put all the areas of amendment in place and approach the National Assembly to do that. Thank you, Mr. President.
Thank you, RG, for the comments. Just to make quick remarks on the issues you have raised. One fundamental issue is the fact that the law is not perfect. Also, you have recognized the fact that it is because a law cannot be perfect. That is why we have an amendment process in place to amend the law. If a law could be amended, if regulations are made that requires amendment, and as you know, it is easier to amend the regulation than to amend the law. And the concern they are raising is not that companies, for at least for all the stakeholders and the professional platform that I belong, companies have unissued shares for various reasons. Some to meet obligations with their strategic investors, so some for other contractual relationship with their employees, and there are timelines when these shares are to be issued based on satisfaction of one requirement or the other. Now, giving a timeline of 6 months to do that is a bit of a concern for them, because the challenge is, do you just give these shares away? And also going back to the Cama, because that is the source of any discussion we'll be having, because if the law had provided for it, it would be a straightforward something. You also agree that section 124 that talks about companies, whether new company or existing companies, that have more below the minimum issue share capital, must do that within a period of 6 months after the commencement of Cama. There is nothing based on what we have seen so far in Cama that provides that a company, an existing company, cannot have unissued shares. The definition section in section 868 that has been referred to defines issued share capital. That definition does not prohibit unissued shares. And if you look at section 13 of the company's regulation, the section actually talks about unissued shares, whereas section 124 of Cama that section 13 is referencing talks about minimum issued share capital. And as you rightly said, no human being is perfect. The good thing is that regulations are made to provide maybe more information about what the law has provided. Regulations basically is not to run in parallel with the law. And the challenge is that it is not that easy for companies to just increase their share capital. And as you rightly mentioned, particularly the public listed companies or the public companies, there are a lot of procedures required, unlike a private company that can just meet. Fortunately, nowadays, they can just do virtual meeting and they just do an increase. But for a public company, it requires a lengthy process for this to be done. In terms of what can we do to move this forward? And I said something before you joined the call. All the engagements that CAC has been participating in, CAC has never maintained a rigid position. It is all about taking a position that will be in the interest of their customers and stakeholders. The request basically is that CAC should look at the provision of Cama and also this regulation. Yes, it's good. CAC is giving an incentive. If you issue your unissued share before 30th of June, you don't pay fees, which is good. It will encourage those who are in a position to do that to quickly do that. But there are some that if you ask them to just issue these unissued shares now, they will need to also do another increase shortly. And to them is just maybe an avoidable stress. And that is why they are looking at why can't, if for example, the law has provided that for as we have for companies with below minimum issue share capital, the law has provided that within 6 months you must update and get to the minimum. There is no discussion about that one, but there is no such provision in Cama, and that is the concern. And that is why we are asking the CAC to look at it, since this is a provision of regulation, not by law. They can always look at it. Yes, the minister has signed. I'm very sure that the minister, if he sees anything that requires maybe an attention that will be in the interest of ease of doing business, I'm very sure the CAC will gladly support. The minister also will not hesitate, so that we can carry all the stakeholders along. And that is the purpose of this discussion, to say, how do we now progress this discussion in view of the fact that your customers are the stakeholders of Corporate Affairs Commission are concerned with this. If you look at the number of people that are joining, and these people that are joining, not only charter secretaries, lawyer, we have chairmen of boards here, we have directors here, is to show
Mr. President, can I intervene on this?
Yes, sir.
Can I intervene on this?
Yes, sir. Go ahead, Arujji.
As I have said, CAC is a very responsible agency. What we will do is, we'll not do a general enlargement, but we'll treat each case we'll treat them on case-by-case basis. So if anybody not be able to comply to meet the 6 months deadline, please write to us. Tell us when you think you can achieve that. And we'll not hesitate to enlarge the time at no cost to you. So once the time is enlarged, based on your own request, then you are free to come forward and do it at the agreed time. So that's the assurance I want to give to stakeholders. I'm sure a lot of them may even prefer to cancel the capital, because maybe the whole essence of putting it there is just, I don't know for what reason. They may not have any reason to issue the remainings. So may never come for either ask for alignment or do otherwise. So we'll treat each case on case by, we'll treat the matter on case by cases. So anyone that may not be able to do it within the 6 months can write to us, and we'll gladly enlarge the time. I think we can look at a window of up to 2 years within which they can achieve that. So it's okay. But the debate about issued share capital definition, I think that will not end, because the definition and 868 actually relates to issued share capital in relation to any reduction of capital. But if you look at the definition of capital, it's clear it means issued share capital of a company at any given time. So that's the capital. So well, as lawyers, we can always twist these things to suit our own purpose, but there's a middle ground. CAC will not be draconian, will willingly grant further extension at no cost, will not charge any penalty for any company that applies to have that extension. I think up to a maximum period of 2 years. I think that will solve the problem, Mr. President.
Okay, thank you, the Arujji. That is also in line with what I said earlier. The Companies and Allied Matters Act is a work in progress. All regulations and enactments in Nigeria, even the Constitution is a work in progress. We'll continue to see how to make it better by listening to stakeholders. We've noted the opportunity you have granted to companies on a case-by-case basis to apply for extension at no cost to them, so that they can also consider their contractual liabilities and obligations, and then be in a position to interface with the Corporate Affairs Commission. And to me, I think the in thing, or the most important thing in life, is flexibility in whatever we do. If God were to be so rigid, maybe there won't be anything called the world today. God has always been magnanimous to change his mind, even when those he has created has done something that is not in line. So I'm very sure a lot of companies that are having serious issue with this regulation will take advantage of that. But I will just request the moderator to go to the Q&A. Let's see if there are questions that you can also provide clarification. Because the good thing, ROG, is this. This is a unique opportunity to also reach out to your stakeholders, your customers. The CAC is there because there are customers. The customers are also there because there is CAC. So whenever we have this relationship or this interaction, it's an opportunity to reach out so that we can also always consider what are the things we need to do better. The customers can understand you better. You can also get an idea of the feelings of the customers so that you can also incorporate that in your process. So that is why I will call on the moderator. Are there comments based on the proposal made by the ROG regarding flexibility, waiver of fee, if application is made to CAC, in respect of enlargement of time for them to take care of their initial shares?
Thank you so much, my president. We also want to appreciate very, very deeply the RG. We have about 45 questions here, but the trend, the common theme for most of the question is that our participants would like to know, for the RG to give an indication of what period of time this extension would be looking like so that it can help for planning purposes.
I just want to respond to that. The ROG has said it will be on a case-by-case basis. So each company will be required to communicate the peculiarities of its case. I think that will assist the Corporate Affairs Commission to actually take a decision, because he stated that he would not want to give a blanket something to say it has to be this. And I think what he has said is that it will be on its merit and on case-by-case basis. So depending on the contractual relationship that every company has entered into, I think that has been answered by the ROG, in my own view.
All right, sir. Thank you. There's also a general concern with maybe the ways of working at the CAC, that most times the CAC staff can be very rigid with treating documents. So I think what we're trying to find out here is, extract some assurance from the RG that this will go all the way down, to be cascaded down, such that when we put in our applications or our requests,
hello,
you have guided. Yes, sir.
RG, please go on.
Sorry, can you take that again?
Okay, RG, just let me clarify the point being presented. RG, I want to clarify the point.
Can you take that again? I didn't hear you.
Yes, I will do that now. I will do that. What the participant wants to know is that how would the Corporate Affairs Commission clarify or communicate this decision to the structure so that they are aware that there is flexibility whenever an application is made, so that if it is filed, somebody will not raise the issue that no, Regulation 13 talks about this. So there is no exception in terms of communication. And I'm not.
Okay, Mr. President. I think we'll do is we'll issue a public statement.
Okay.
In the media and on our website, we'll issue a statement in the national newspapers, maybe a paid advertisement on this position, and that will give opportunity for companies that want to take advantage of it to actually apply.
Okay. So thank you for that clarification, Haruji. I think that is noted. Yes, it's clear. It's clear enough. Moderator.
Yes, sir. I'm just looking at, because most of the questions are very, very similar, and a lot of them have been answered by the comments and the remarks we've received from the RG. Okay. A lot of them order on the timing, as well as the clarification on the regulations 13 vis-a-vis 868 that we have gotten some clarifications on.
Okay, so if that is the case, let me just thank the RG for the clarification provided. And particularly, let me say something. Since 2020, when you were appointed, by the way, RG, you have not celebrated your anniversary of your appointment. It was 1 year last month.
It has been walk, Mr. President.
I know. It's you know, your situation. I was discussing.
No time for celebration, Mr. President.
Yes, I was discussing with a stakeholder recently. I said, you know, the more you start having children, the more visitors will be visiting you. I know it has been hectic since last year. COVID came, you came up with regulation, thereafter Cama came, regulation came, and it has been one engagement after the other. I must tell you that it's a worthy engagement. And a worthy engagement in the sense that you just need to interact with your people. And on behalf of some of my, at least a lot of our members that dealt with you, that have been interfacing with you since last year, we must commend the promptness in which you respond to letters written to you. It has been a sustained trend in the sense that regularly, whenever letters or mails are sent to you, you hardly delegate your response. You handle them personally, which is highly appreciated. It is our hope that this will continue. And also engagement section that you are being invited to join. It's our hope that as we continue, that you also sustain that so that you can listen to people. And particularly the flexibility that you have adopted, not on this particular issue alone, on almost all the engagement platforms that you have participated in that I joined, you have not maintained a rigid position. And that is a very, very important characteristics of any progressive person. These laws are not made by us. These laws are made by the National Assembly, and the regulations are made by stakeholders. And because we are human beings, there are bound to be issues, there are bound to be gaps, and we should always be willing to look at those gaps objectively without holding on to a particular position. The only position we can hold on to is the position that we facilitate the progress of the economy. And that reminds me what President Buhari said in his budget presentation in 2016, that the OSS of government is to facilitate business, and that all agencies of government must support businesses to thrive. And I think CAC is demonstrating that, and we hope that will continue, so that as you continue to honor these engagement platforms, you are able to explain your position to stakeholders, and stakeholders are also able to communicate their concerns to you, so that you can always consider them objectively without having any rigid position, so that we can always move to the desired heights that we are looking for in our economy. So we appreciate that. Before I go back to the moderator, just to inform the participants joining here, we happen to have a particular area of interest in mind in Nigeria, the Institute of Chartered Secretaries and Administrators of Nigeria, and that is corporate governance, and that is why we are referred to as the hub of governance professionals. We run a weekly radio program between 10:15 a.m. and 10:30 a.m. every Wednesday on Echo 89.75. And also, we are running exclusively a corporate governance platform program on television, on MITV television, every Thursday from 4:30 to 5 o'clock p.m. every Thursday. So DSTV 255. So if you want to know more about corporate governance, join these two programs. Our own contribution to development of the economy is to support businesses to thrive. And you can only have successful businesses when we have good corporate governance structures in place. And so we encourage you to join and also participate actively so that you can advise your stakeholders accordingly. So on that note, I go back to the moderator for the closing comments.
Thank you so much, Mr. President. On behalf of the Institute, the Chairman and President of Council, we want to thank you very, very much, our RG, Alhaji Garba Mohammed. We appreciate the time you have spent with us during these engagements, as well as the clarifications you have provided, sir. We do not take it for granted. Like the President has said, every time we call, we always get an answer from you. So we do appreciate you deeply for helping us this afternoon to make those clarifications. And of course, for telling us that in order to facilitate this process and make it an enduring conversation, we're going to get a circular that will be published so that we can have that on record and also show that to all of our multiple stakeholders as we progress on this journey. So thank you very much, sir. I also want
thank you for having us.
Thank you so much. And also for Mr. Justin Nidia, who started this conversation on behalf of the RG, as well as our Mr. Tolu Lope Shonaike. We're really grateful for having the team, a powerful team from the Corporate Affairs Commission. On that note, we also like to thank you so much, sir. We want to thank you, our participants. We've had almost 350 participants from various sectors, very distinguished VIPs amongst us, the chairman, the board of directors, as well as other key stakeholders joining to have this conversation this afternoon. So we thank you. We thank you for all the questions, all the comments. This is not the end of this conversation. We know that we're going to continue with this even outside this forum. We can assure you that we will issue a communique to just summarize all the highlights and the critical elements that have been discussed and agreed this afternoon. We will have that uploaded on our website as soon as possible. So please visit Icsan, www.icsan.org. You will see so many information and so many materials that will be of great assistance. We want to thank you for turning up and making it such a very, very enlightening and wonderful session this afternoon. On that note, I will want to ask the President maybe for his final word, a final word from the President as we close this webinar.
Okay, the final line for me is that we request all the participants who are yet to join the Institute to apply to be a member. You can join. I believe a majority of us are graduates. You can join our professional examination stage. That is stage 1, and you have some exemptions. If you are very experienced personnel, you've acquired very good length of experience over the years, legal practitioner for more than 15 years, company secretary for more than 15 years, you are a professor of law or corporate governance teaching in the university for 15 years, you can apply to join the Institute through the fast track program that is ongoing. Go to our website to download the form and submit by the 4th of March, which is the closing date. It's an opportunity for you to know what is happening in the world regarding corporate governance. That is our main area of focus because that is the only thing that can sustain business generally. So we appeal to you to also participate in our program. Join the corporate governance platform on radio every Wednesday, 10:15 to 10:30. The corporate governance platform on TV, MITV, channel 255, between 4:30 and 5 p.m. And you'll be glad that you have joined a professional institute that is a member of the Corporate Secretaries International Association globally, and that has a focus towards developing corporate governance. So it's on that note, I thank all the council members, our past presidents that are joining us today. We appreciate you, and the management and staff, we also thank you for your support. And also I thank the moderator for making out time to handle this particular event. That has been an area of competence. She is Mrs. Biola Lashende, the chairperson of the Corporate Members Committee of the Institute of Chartered Secretaries and Administrators of Nigeria. So we thank you.